Breaking tonight at this hour, the Colorado Supreme Court has disqualified former President Trump from the state's 2024 election ballot over his involvement in the Capitol riot of January 6th.
In an unprecedented decision, which was powerful, reasonable, and yet still remarkably surprising, the Colorado Supreme Court has ruled that Donald Trump is an insurrectionist who violated Section 3 of the 14th Amendment and is therefore disqualified from holding any public office, including the presidency of the United States. But before we unpack all that, if you haven't yet, please hit that like, subscribe, and the alert bell. All right, folks, we've got a couple of clips to play here. We're going to look at excerpts from the 130-plus page majority opinion from the Colorado Supreme Court. But this is a monumental decision, a monumental moment in the history of the United States. I'll say up front, it is not the end. This will almost certainly go before the United States Supreme Court, which has a 6-3 conservative supermajority, 3 of whom were appointed by Trump himself when he was president. So this is not the final word. We may yet see a reversal. But let's watch some of the clips, beginning with my favorite, which is Fox News talking about it, because that's always sweet.
Breaking tonight at this hour, the Colorado Supreme Court has disqualified former President Trump from the state's 2024 election ballot over his involvement in the Capitol riot of January 6th. Again, just getting this in, the justices have stayed the decision until January 4th to allow for the inevitable appeals, but they have stepped in and disqualified him from the Colorado ballot. It's just breaking this out.
Huge. No doubt people on the Fox Propaganda Network and elsewhere are going to be raging out. Before I play the next clip, I am going to remind you of what Section 3 is. So it's part of the Reconstruction era amendments. It was adopted in the aftermath of the Civil War, and it was essentially an attempt by the framers of the Civil War era 14th Amendment to keep people who broke their oath to the Constitution, engaged in insurrection, were part of the Confederacy, from ever wielding power and public office again. Basically, you betrayed the country, you have no right to help govern the country. No person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such a disability. Okay, that is the text of the 14th Amendment. We're going to play this other clip, and then we're going to start unpacking the majority's opinion on the Colorado Supreme Court.
The Colorado Supreme Court ruling that Donald Trump has now been disqualified from being on the primary ballot for the GOP. Again, this breaking news out of Colorado. Donald Trump, as we know, was fighting to be able to be on that primary ballot. The Colorado Supreme Court now issuing a 200-something page opinion that we've just got. And we're going to go back to Christy Greenberg and Hugo Lowell. I know, guys, you haven't had a chance to look at it. We're looking at it right now. It's 217 pages. But, Christy, I want to start with you on this particular issue. This is not the first state that there's been an attempt to be able to disqualify Trump being able to be on the ballot. But what's intriguing about it is that it's now being done in a way where the judicial system is having a say in terms of whether or not somebody can be on a ballot. Your thoughts about what we're hearing coming out of Colorado at this time?
Well, it is an interesting decision because the Colorado District Judge, Sarah Wallace, last month, when she made her decision, she had a really puzzling decision where she found, based on the evidence, that Trump had engaged in insurrection, but essentially said, well, Section 3 of the 14th Amendment, it doesn't apply to presidents. He's not an officer such that it applies to him, which was a really odd result. So when that was appealed, I think a lot of people had been scratching their heads and thought the appeal was appropriate. And, I haven't read the basis of this, but it sounds like at least the Colorado Supreme Court said no. Actually, if he engaged in insurrection, yes, he is an officer, and the 14th Amendment would apply to him. It would be a perverse result otherwise to have it apply to members of Congress and others in lower elected officials and not to the President of the United States. So it sounds like Colorado Supreme Court got it right in finding that this should apply to the president, and presumably determines that the factual findings of the district court in finding that he engaged in the insurrection were upheld.
They were upheld. Again, we'll unpack some of these excerpts together, but the last thing I want to just remind everybody. So Trump has already issued a statement from his campaign. He will appeal to the United States Supreme Court. Tuesday's ruling only applies to Colorado, and this is according to the New York Times. But if the Supreme Court were to affirm it, he could be disqualified more broadly. The Colorado Supreme Court stayed its ruling until January 4th, 2024, to allow time for Trump to appeal to the U.S. Supreme Court. If he does, the ruling could be stayed for longer while proceedings unfold. All right, folks, so with that in mind, we're going to look at some excerpts here. Again, people are saying it's a 200-plus page opinion. That's if you count the dissenting opinions, and there were 3 dissenters on the seven judge Colorado Supreme Court. There's 7 justices, 3 of them dissented, 4 of them affirmed. So we're going to look at parts of the majority opinion. So this is the introduction, and they said, listen, after permitting Donald Trump and the Colorado Republican State Central Committee to intervene in the action below, the district court conducted a 5-day trial. The court, and they're talking about the lower court, found by clear and convincing evidence that Donald Trump engaged in insurrection, as those terms are used in Section 3. So then they say Trump sought this court's review of various rulings by the district court. We affirm in part and reverse in part. We hold as follows. The election code allows electors to challenge Trump's status as a qualified candidate based on Section 3. Congress does not need to pass implementing legislation for Section 3's disqualification provision to attach, and Section 3 is, in fact, self-executing, so it's automatic. Judicial review of Trump's eligibility for office under Section 3 is not precluded by the political question doctrine, which is this idea that important political questions are non-justiciable. The Supreme Court should stay out of it. They're saying, listen, this doesn't count. This is a matter of constitutionality, not just politics. Then, this is where they reverse the lower court. Section 3 does encompass the office of the presidency and someone who has taken an oath as president. On this point, the district court committed a reversible error. The district court did not abuse its discretion in admitting portions of the January 6th report. The district court did not err in concluding that the events of the U.S. Capitol are an insurrection on January 6th. And the district court did not err in concluding that Trump engaged in insurrection. Okay. And then they finally say that Trump's speech on January 6th is not protected by the First Amendment. So then they say we do not reach these conclusions lightly. We are mindful of the magnitude and weight of the questions now before us. We're likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates that we reach. So they're saying, listen, this is really awkward. We know we're going to get a lot of flack for this. We know this is tense. We understand all that, but our understanding of our constitutional obligation and the Constitution itself requires us to reach this conclusion. So we're going to look at some other things. Reconstruction ushered in the 14th Amendment, which we discussed, addressing what to do with those individuals who held positions of political power before the war, fought on the side of the Confederacy, and then sought to return to those positions. In interpreting a constitutional provision, our goal is to prevent the evasion of the provision's legitimate operation and to effectuate the drafter's intent. I want to make sure I didn't skip something. Okay, good. Okay, so we're going to go to the next one. No party in this case has challenged the Secretary of State's authority to require a presidential primary candidate to conform to the required statement of intent. Okay, basically what they're saying is nobody here challenges the fact that the state Secretary of State is basically allowed to keep people who are not qualified from holding public office off the ballot. None of you contest that. So now the question is, does Donald Trump meet that standard? And they do. So They say here, if the court were to adopt Trump's view, Colorado could not exclude from the ballot even candidates who plainly do not satisfy the age, residency, and citizenship requirements of the Presidential Qualifications Clause of Article 2. It would mean that Colorado would be powerless to exclude a 28-year-old, a non-resident of the United States, or even a foreign national from the presidential primary ballot in Colorado. Yet, as noted, several courts have upheld states' exclusion from ballots of presidential candidates who fail to meet the qualifications for office. Okay, so they're saying this makes no sense whatsoever. Of course, we can keep people who are not plainly qualified to be president off the ballot, and it's backed up by plenty of law to support that. Section 3 does not determine who decides whether the disqualification is attached in the first place. So they're talking about whether or not Section 3 is self-executing or not, or if it requires an agency or additional legislation to review. The Supreme Court has said that the 14th Amendment is undoubtedly self-executing without any ancillary legislation, as far as its terms are applicable to any state of circumstances. So the Supreme Court has held the 14th Amendment doesn't require a congressional agency or a congressional statutory law to enforce. It is automatic, which would include Section 3. Thus, while Congress may enact enforcement legislation pursuant to Section 5, which says that Congress can do that, congressional action is not required to give effect to the constitutional provision. So they're saying Congress can act, they can appoint an agency, they can give clarifying legislation, but it's not necessary. Section 3 of the 14th Amendment applies, and it's automatic. When interpreting the Constitution, we prefer a phrase as normal and ordinary usage over secret or technical meanings that would not have been known to ordinary citizens at the founding generation. So what they're saying is when we talk about is the president an officer or not, we don't need to use secret code. It's pretty straightforward. Would people at the time have understood the president to be an officer? They would. So they point out that even Trump doesn't deny that the presidency is an office. Instead, they assert it's not an office under the United States. Their claim is that the president and elected members of Congress are the government of the United States and cannot therefore be serving under the United States. We cannot accept that interpretation. A conclusion that the presidency is something other than an office under the United States is fundamentally at odds with the idea that all government officials, including the president, serve we the people. A more plausible reading of the phrase under the United States is that the drafters meant simply to distinguish those holding federal office from those held under any state. The Constitution refers to the presidency as an office 25 times. And then they point out issues with the idea that the president isn't an officer. So they say, consider the impeachment clause, which reads that Congress can impose as a consequence of impeachment a disqualification to hold and enjoy any office of honor, trust, or profit under the United States. If the presidency is not an office under the United States, then anyone impeached, including a president, could nonetheless go on to serve as president. This reading is nonsensical, as recent impeachments demonstrate, which is absolutely true. Then they say to read office under the United States to exclude the presidency would mean that a sitting president could also constitutionally occupy a seat in Congress, a result foreclosed by basic principles of separation of powers. And that goes back to the idea that you can't be a member of the executive branch and the judicial branch at the same time. You have to pick one. There's supposed to be a separation of powers. So what they're saying is if the presidency isn't an office, then that means the sitting president could also be a senator. And that's that's just absurd, even going back to the founding of the country. Then they point out the emoluments clause provides that no person holding any office of profit or trust under the United States shall, without the consent of Congress, accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. To read the presidency as something other than an office under the United States would exempt the nation's chief diplomat from those protections against foreign influence. And yet, that's never been the case because we understood that. Let's see here. Actually, we scrolled down through that. We'll just go ahead and skip to the conclusion. The district erred by concluding that Section 3 does not apply to the president. We therefore reverse the district court's judgment. As stated above, however, we affirm much of the district court's reasoning on other issues. Accordingly, we conclude because Donald Trump is disqualified from holding the office of president under Section 3, it would be a wrongful act under the election code for the secretary to list Donald Trump as a candidate on the presidential primary ballot. Therefore, the Secretary of State may not list Donald Trump's name on the 2024 presidential primary ballot, nor may she count write-in votes for him. Folks, this is huge. This is absolutely huge. The fact of the matter is this is the first court to disqualify a former president from running for office again. Now, again, it's not the final decision. And as a matter of fact, Donald Trump didn't win Colorado, right? He lost Colorado pretty badly in the 2020 election, so it's not like he necessarily needs Colorado to become president again. But there are two risks here. Number one, the United States Supreme Court could say absolutely Donald Trump is an insurrectionist and he did violate Section 3 of the 14th Amendment, or they could simply affirm the ruling such that they leave it up to the states to make that determination, which means that other states could follow suit, right? And of course, there's the possibility that the 6-3 conservative supermajority, again, half of whom were appointed by Trump himself, will strike down this ruling. It's entirely possible. But this is huge. This means that there is a justiciable case to make, and there's plenty of legal backing. We've talked about it. We've done so many videos about this. I don't feel the need to regurgitate everything. But they upheld that Donald Trump is an insurrectionist, that he did violate Section 3 of the 14th Amendment. The Section 3 of the 14th Amendment does apply to the President of the United States, which makes absolutely no sense, or absolute sense. It doesn't make any sense whatsoever to assume that the presidency would not be covered. Hey, we want to keep insurrectionists and betrayers out of office, except they can go ahead and have the highest and most powerful office from which to be a betrayer and insurrectionist again. It's just categorically on its face ridiculous. So I'm glad that the Supreme Court, Colorado Supreme Court, struck this down. Folks, this is huge. It's not the end, but I'd love to know what you think. Let me know what you think one way or another in the comments.